as we return to studying the challenges posed by artificial intelligence and its regulation. I want to welcome for the second hour today from the offices of the Information and Privacy Commissioners of Canada, Mr. Philip Dufresne, who is the Privacy Commissioner of Canada. Always good to have you back with us, sir. And Marc Chenier, who's the Deputy Commissioner and Senior General Counsel. Mr. Dufresne, you have up to 5 minutes to address the committee. Go ahead, please.
Monsieur le Président, Mesdames et Messieurs les membres du comité.
Mr. Chair, members of the committee, thank you for the invitation to appear as part of your study on the opportunities and considerations raised by AI and its regulation. Taking into account the privacy impacts of fast-moving pace of technological advancements is one of my strategic priorities. It has always been at the focus of my domestic, cross-regulatory, and international work over the last few years, given its rapid and broad adoption by individuals and organizations in Canada and around the world.
And timely issue for Canada. As more and more personal data is being collected, used, and shared, data protection becomes increasingly significant for Canadians and Canadian organizations. The protection of personal information is particularly important in the context of AI, as personal information can be used to train and operate those systems. Recently, I announced an expanded investigation into the social media platform X and its Grok chatbot. The investigation will examine the emerging phenomenon of AI being used to create deepfakes, which can present significant risks to Canadians, including children. Je m'attends à ce que les résultats de cette enquête.
I expect the results of this investigation, as well as my ongoing investigation into OpenAI, help inform privacy and policy direction with respect to AI, and help individuals and organizations use and deploy these technologies in a safe, responsible, and with appropriate protections for personal data. Investigations by my office over the last 2 years have demonstrated how Canadian law is able to address major privacy issues that can have serious impacts on individuals.
Investigation into ALO, which operates Pornhub and other pornographic websites, addressed non-consensual sharing of intimate images. My joint investigation with my UK counterpart into the 23andMe breach examined an incident that impacted the highly sensitive personal information of 7 million customers, including more than 300,000 Canadians. Last fall, I announced the result of my investigation with my provincial counterparts into TikTok, which highlighted the importance of protecting children's privacy online. Because of our investigation, the company has implemented and continues to implement improvements to its privacy practices in the best interest of its users, especially children. Technologies such as AI can bring economic, social, and public interest benefits. The value of this innovation will be maximized when it is accompanied by trust. Un sondage mené par le commissariat l'année dernière.
Survey conducted by my office last year found that a significant majority of Canadians are concerned about how their personal information is collected and used. In fact, 80% of them indicate that they are concerned about their privacy when they use AI tools. Many have taken actions to protect themselves. Most indicated that they are less willing to share their personal information with organizations compared to 5 years ago.
For organizations to develop and deploy AI and other technologies in a responsible, privacy-preserving manner. It is key for developers and providers of AI to embed privacy in the design, conception, operation, and management of their products and services, and to consider the unique impact that these tools have on children, as well as on groups that have historically experienced discrimination or bias. Organizations that use AI should be transparent about this use and accountable for any AI-generated decisions about an individual, such as whether to grant someone a loan or a job. Alors que les technologies continuent d'évoluer rapidement et s'intègrent.
As technologies continue to evolve rapidly and become increasingly integrated into our personal and professional lives, it is our collective role as regulators and policymakers to make sure that privacy is protected for current and future generations. Canadian privacy laws must be able to meet this challenge. And to do so, these laws will require modernization.
Amendments to Canada's federal privacy laws include recognizing privacy as a fundamental right, as well as establishing requirements to implement privacy by design and to conduct privacy impact assessments for high-impact data processing. Personal information is at the heart of artificial intelligence, and therefore, privacy legislation should, in my view, be at the heart of AI regulation. Thank you. I look forward to your questions.
Okay, thank you, Mr. Dufresne. We're going to start with Mr. Barrett for 6 minutes. I'm going to keep it tight, on time. Mr. Barrett, start for 6. Go ahead.
Tell me about what have been called Chinese spy cars. And the Premier of Ontario, Mr. Ford, has expressed serious concerns about the plans for the Canadian market to accept nearly 50,000 vehicles manufactured by companies like BYD. And what your office is taken a look at so far with respect to those vehicles and that claim, perhaps informed or otherwise by Mr. Ford.
Thank you for the question. I have heard those statements, and we are monitoring the situation generally with respect to connected vehicles. We've, in fact, this year launched our contribution program on the theme of connected devices and looking forward to finding out more about the types of connection, the types of data information that is collected by cars and other types of devices. In terms of the Chinese angle, we are not looking at this specifically, but in the context of our Tik Tok investigation, one of the elements that we highlighted in our conclusion was that when data will leave Canadian jurisdiction, when there is a risk that other governments can have access to this information, this is something that Canadians should know about. This should be transparent. And so in our Tik Tok report of findings, we requested and the organization agreed to make this explicit.
Just on TikTok, do you have a recommendation for Canadians on whether or not they should use the app?
Well, our recommendation to Canadians is that they should ask questions about this app or any app, and frankly, any situation where their personal information is being sought. Asking, why do you need it? What will you do with it? Who will you share it with? And so in the Tik Tok investigation, we addressed these head on, looking at what is the organization telling Canadians? Because it's one thing for citizens to ask questions. Organizations have a big responsibility to be proactive in this transparency. And so in the Tik Tok case, we found that the information wasn't clear enough. It wasn't clear enough for adults, and it was certainly not clear enough for children, which is a huge part of that market. So questions like the use, the sharing, the purposes, where it's going, who can have access to it. So Canadians should ask more of these questions, but organizations should proactively take the responsibility to make that information easy to find.
Have you seen a change in the proactive information offered by TikTok to Canadians since you made those recommendations?
Well, I would say yes, because we are working with them and monitoring the implementation of our recommendations. Our recommendations had a 6 months period to put them in place. A big one was better tools to keep children, underage children, off the platform altogether. And others had to do with the transparency, with the consent, with the information. So they've implemented a number of those, and they have until March to complete the rest. And we're going to be monitoring that to make sure this happens.
And what's the outcome if they were to, so first of all, based on their cooperation to this point, it's your expectation that they'll meet the deadline? And should they not, what would be the outcome?
Well, should they not, then one of the gaps in privacy legislation is I don't have order-making powers.
Right.
And so we have to count on their collaboration, and we have to work with them. And so far, it is working, and I'm cautiously optimistic that it's going to continue to work. But this is why a key element of law reform has to be order-making powers for the Privacy Commissioner.
Pressed for time, I'm gonna move on. I just want to ask about your investigation of X Corp, and this is incredibly important. Obviously, the harms that are being done in real time especially, but not only to children, but especially to children, with the non-consensual images that are being propagated, being created. It's alarming. What kind of a position are you in your role as a Canadian commissioner, with the lack of order-making power? Do you lack the enforcement tools necessary to be able to effectively execute your role in a way that would protect Canadians, especially children, in a situation where the gravity of it can be lost on no one?
Well, I'll say two things. One, I need to have order-making powers. This should be a top priority for Parliament. I'm encouraged by statements from the Minister of AI that modernization is something that's being contemplated. That being said, I am and will continue to use the existing tools that I currently have to protect Canadians' privacy, with investigations, with the recommendations, but also working with partners in Canada and internationally. So in the context of deepfakes, we have issued statements calling this out as early as December 2023. We're working with international partners to bring the international community together in taking steps. And so that's one thing that I've done, for instance, in the 23andMe case in terms of the breach of Canadians' information. I don't have order-making powers. My UK counterpart does. And together, we did that for Canadians.
Thank you. Thank you, Mr. Dufresne. Mr. Barrett, Monsieur Sarré, pour 6 minutes.
Mr. Sari, you have 6 minutes. Thank you. Before asking my question, I want to go back on your mandate, which is the overall protection of privacy. They are based on fundamental issues such as transparency and accountability, and the ability for individuals to understand and challenge AI solutions. And however, you know that AI changes how decisions are made. For example, whether it's Gen AI or cognitive AI or agentic AI, there are things that do not give us that decision-making capability. It's like this black box. We do not see the decision-making patterns. So my first question for you, in such a context, we see that technology is evolving very quickly. How does your office evolve and assess real human control? Can we talk about whether there is real human control? Well, you're entirely right. Privacy principles can change over time because these are fundamental issues that affect freedom, dignity, the ability to choose what we share with who. Now, with technology, we are facing serious issues because technology is evolving very quickly. So organizations like mine need to play catch up. We need to know how these tools work. We need to have the technological ability, and we have created that in my office, to understand that technology and to act accordingly. When it comes to human decisions, we also need to raise these issues, whether that's in legislative reviews or reforms. For example, more transparency in the world of AI to understand how decisions are made, but we also have to make sure that humans are in the loop. Recently, I was at the World Assembly for Privacy, and they put forward a resolution adopted by the international community related to the role of humans in AI and what that needs to represent. So it's a very relevant issue, and that kind of solves the issue of the black box. So it's more of a technological black box. That's how neural networks work, right? You cannot walk back on that and change it. It started back in the 80s and will keep working that way. So you talked about understanding technology. Do you believe that the right to privacy is still fully respected right now? There are certainly cases where it is not respected. We talked about the TikTok decision where we saw shortcomings in that field. The same went for Staples. So there are issues. What is important is to have the tools to deal with these shortcomings. Ideally, we work in a preventative measure, but if not, we can do it after the fact. And I believe there's technologically neutral solutions that can evolve with technology. However, the law needs to be modernized to make it easier. For example, this identification and transparency. How can you add transparency when organizations themselves are saying that they do not understand why they arrived at certain decisions? The chair of Google recently said so. However, the PIPEDA creates a good framework. I'm reassured by the fact that you talked about frameworks because all the articles that I have read brought forward the issue of the opacity of AI technology. I understand your role. I have a lot of respect for it. I think it's an essential role. And your work reassures me. On my end, when we want to talk about control, as House of Commons, as a committee, what should we do so that we can be able to control things with the knowledge that there is opacity? In my opinion, the most important thing that you can do as parliamentarians is to amend the law. It's an essential tool. I made 7 priority recommendations to the government that I have shared with the committee. For example, we talked about stronger law enforcement powers, recognizing privacy as a fundamental right. It is more important than ever with AI. For example, privacy at the onset. So when organizations create a tool that has a lot of impacts, privacy needs to be included at the start and not at the end. And then we need to talk about data that will leave Canada. We need to build a framework around that. So we talk about information collection as well as processing it, secure it, and then transmit it abroad. So when you talk about protecting privacy, it's related to all of that. But now back to individuals. Do you have a vulnerability category for people? Who are the most vulnerable? We talked about young people. We talked about women. Are certain groups more vulnerable than others? Very quick answer, please. Young people are very vulnerable because they are swimming in it. You're right. Women, the same goes for seniors. There are a lot of groups who need to be protected. Thank you, Mr. Terrier. 6 minutes. You meant Mr. Terrier, Mr. Chair. Welcome, Mr. Commissioner. You talked about the international aspect. Mr. Chair? Point of order. I do not hear Mr. Terrier too well. I think it's better now. I will restart the clock. Thank you. I want to talk about the statement made by G7 leaders who said that they need to work together to accelerate AI adoption in the public sector and to improve services to accelerate services to people and businesses while protecting human rights and also while ensuring transparency and fairness. They also want to promote economic prosperity by encouraging small and medium businesses to adopt AI that will respect IP rights as well as personal rights. Inaudible for the interpreter. We also improve competitiveness and productivity. What should the key elements of the G7 leaders adopt when it comes to an AI centered on humans? So you refer to the G7 leaders' statement. G7 privacy commissioners had our own meeting at Lake Meech. And in June, we made a unanimous statement on the importance of prioritizing privacy for two things: to promote innovation and the economy, and to protect children and other people. And we did refer to the leaders' declaration on that, and we provided concrete examples. For example, taking into account the best interest of children and of people when technologies are being created and put onto the market. The importance of privacy at the onset and not at the end. We also talked about how transparency is important, how it's important to talk to people to create trust. A lot of people say that, well, a strong privacy system can limit innovation, and I challenge that, and our statement at the G7 also challenged that. In fact, we say that it will encourage innovation, it will support economic development, because it will lead to more trust amongst people, amongst consumers towards this technology, and we see it in the surveys that I have referred to earlier. So it is essentially from a rights perspective, if we want to protect people, it's important for all of us, for our freedom and dignity. But from a pragmatic perspective, it will also help the global economy and especially the Canadian economy. So we sent a strong message in Ottawa, and I was very proud of it. And we are still promoting it here and everywhere else. So when it comes to improving the quality of public services and the improvement of government productivity, how can you reconcile the acceleration of AI adoption with the respect of privacy, as well as the promotion of transparency, fairness, and accountability? Well, we need to strike that balance. Tools will improve productivity. They can support all kinds of economic development. They can also support improvements in healthcare. It can improve citizen services. That's all great. But it needs to be done so in a humane and transparent manner. It needs to be centered on humans. And it needs to respect fundamental issues when it comes to respecting privacy. For example, no consent. For example, back in September, we conducted an analysis with the Competition Bureau and the CRTC and the Copyright Bureau related to what we call synthetic media, commonly called deepfakes. So we asked, what are the key issues? In some cases, technology can help create pictures, but if it's used to manipulate people, if it's used to create non-consensual sexual images, that crosses lines. That should not be crossed. So you cannot say innovation or privacy. Canadians need to have both. Work is a fundamental right. We can say it's part of human rights. People have come to us and said, for example, they often hear that people want to replace white-collar workers with AI. And once you reach this critical mass of people who have lost their jobs, how can you reconcile AI advancement? Because we're talking about the G7. And these people have made the state more productive. So when it comes to job protection, that is outside of my mandate related to privacy. But when you protect privacy, you protect individuals. You make things more transparent. You gain a better understanding of things. And then you can value what's human and what is not. And that may be part of the goals and the solutions. For example, saying maybe not compete with AI on things that are purely related to statistics and probability. However, the human advantage needs to be kept, and it will also be a critical advantage. Thank you, Mr. Thériault. And that is it for the first round, and we will now move on to the second round. Mr. Cooper, 5 minutes.
Mr. Chair, Commissioner Dufresne, the Prime Minister recently struck a deal with Xi Jinping to allow for the import of 50,000 Chinese EVs annually. He did so notwithstanding serious concerns regarding national security, regarding privacy concerns, including audio and video surveillance, as well as tracking people's movements. Premier Ford has characterized these EVs as spy vehicles. Others have also characterized them in the same way. The U.S. has a functional ban on vehicles that contain Chinese software. So in the face of these very serious concerns that go directly to the privacy of Canadians, did the Prime Minister's office or the Minister of International Trade or anyone in the government consult with your office about these concerns before striking a deal with Xi Jinping?
We were not consulted about this trade effort with China.
Thank you for that. About an hour ago in the House, the minister responsible for AI indicated that the government would be tabling updated PIPEDA legislation in the near future. Have you been consulted about that updated legislation?
Yes, I have. Myself and my team have been in communications with the department, and I am I'm pleased with how those exchanges have gone.
Okay, and do you expect that PIPEDA, the updated legislation, will give you the order-making power that you said moments ago that you need and that you do not have?
Well, that's going to be up to the government tabling the legislation. But my expectation, my hope, what I can say is I've made very clear to the government and to the House and to Parliament that this is one of my top priority recommendations, that I need a stronger enforcement power, and I am optimistic.
Okay. Changing gears a little bit, the Supreme Court, in its jurisprudence, in the Spencer decision, in the Bykovitz decision, has been clear. Access to personal information or personal data requires prior judicial authorization, correct?
In criminal cases and in administrative law cases, it wouldn't necessarily be the same.
Now, under the Liberal government's so-called cyber security bill, the Minister of Industry has the power to order a telecommunications service provider to collect, retain, and share with the minister things such as metadata, subscriber account information, website visits, the location of financial data, among other personal information, correct?
Yes.
Okay. And constitutional jurisprudence has recognized that metadata such as internet browsing activity is highly sensitive personal information that is protected by Section 8 of the Charter, that everyone has the right to be secure against unreasonable search and seizure, correct?
That's my general understanding of that jurisprudence, and under my legislation, sensitive information is entitled to higher levels of protection.
And that's because metadata can reveal a lot about someone's online activities and their personal life, among other privacy issues, correct?
Yes, the Supreme Court in Bykovitz talked about that, how much you can glean from this type of information.
Right. And Bill C-8 does not require the Minister of Industry to obtain prior judicial authorization as a precondition to ordering the collection, retention, and sharing of this highly sensitive personal information, such as metadata, does it?
No, it does not. Again, this is not in a criminal context, and I should say that I appeared before the SICU committee on C-8 and shared my recommended amendments to C-8, which include necessity and proportionality framing for the exercise of those powers.
And do you believe that there should be a requirement for the minister to obtain judicial authorization? Should it be narrowed, as opposed to as it is currently written, in which the minister would have really broad powers to order the collection, retention, and the transferring of privacy information that the Supreme Court has been very clear about requires judicial authorization.
Right. Well, in my testimony, I highlighted that there is a balancing between the national security objectives, but that this is where necessity and proportionality become important. So in some parts of the bill, I highlighted that you only had necessity or
and so it would be fair to say at present it's not fully adequate from the standpoint of protecting Canadians' privacy interests. There's room for improvement.
I've made recommendations on the standard. I've made recommendation on information sharing agreements and also on notification to my office in cases of breaches.
Thank you, Mr. Cooper. Ms. Church, 5 minutes. Go ahead.
Thank you. Welcome, Mr. Dufresne, and thank you for once again being at the committee here and for all the work that your office is doing to shed light on some of these emerging and concerning privacy issues that we're seeing, particularly with AI and digital tools. I want to take you first in maybe a different and more positive direction, which is to say in a lot of the work that I do with seniors, with persons with disabilities, families, caregivers, I hear a lot about the challenges of navigating through government systems, navigating between provincial and federal systems, application processes. And one of the things I'm interested in a modernization effort is how can we better use data to support modern service models, proactive benefit eligibility, simplification of access to services. Are there anything that you're proposing in this modernization that would help us deliver services better as a government?
Well, I think that this is a very important point in the sense that privacy does not and should not stand in the way of the public interest. And so good government service delivery, data can help with that. Data can help even with protecting privacy itself in terms of privacy-enhancing technology. So I think in part of my recommendations, I'm talking about privacy by design, privacy impact assessment, for example. This is a great tool where if you have a process where you're going to be sharing information because you need to share it, or you're going to use it because you need it to make better decisions for Canadians, that transparency is important. That assessment is important. So in many cases where I will be asked for my views, I'm not going to say, don't do it. Don't give the police this tool if it's warranted and if there's a need for it. But it's going to be, is it necessary and proportional? Is it transparent? Have you assessed it? And my recommendations for amendments to both private sector privacy law and public sector privacy law go in that direction. Make sure that you have, for instance, right now, privacy law does not require for the public sector necessity and proportionality as an assessment. I think it should. I think this would allow for more sharing of information and use of information, but in a way that keeps Canadians' trust.
That safeguards that data, safeguards that privacy. No, I would agree with that. Can I ask you a little bit about the work that your office has undertaken around a children's privacy code, and just in terms of an update to the committee as to where that's at and what are the next steps?
Absolutely. Well, and this is another area where law reform would be beneficial, because in the previous Bill C-27 that was before the last Parliament, there was an element in there that would create the ability to have codes of practice that I would approve and that would give some protections to organizations, but also some obligations and some predictability. So Children's Code would fit very well in that regime. Right now we don't have that, so the Children's Code that I am working on putting in place is going to be setting out my office and my expectations to organizations. Things like best interest of the child, making sure that you have privacy protections by default if you're geared to children, making sure that the consent and the information is shared in a child-appropriate way. So all of that is underway with consultation with stakeholders of Canada and around the world. And a part of that also is the notion of age estimation and age assurance, and making sure that you're keeping kids off certain websites like TikTok if they're underage. How do you do that without going too far in taking too much personal information? So it's that balance that we want to help reach.
It's early days, but are you looking to any of the experience or lessons learned from early implementation of age verification in Australia?
We are, and we're working very collaboratively with colleagues from Australia, from the UK, from around the world, really looking at, we've issued some international statements about what do we want to see. So we want to see something that has data minimization. We want to see something that is transparent, that isn't used for more things than what it should be used, something that is secure against privacy breaches. So all of these, it's really an area where the international community is looking and is working, and Australia, quite rightly, because of their approach to social media, they've had to really accelerate that.
And you've mentioned order-making powers as one of the tools that you're looking for. Can you enlighten us with the other tools or capabilities that would be useful for your office to take something like a code and make sure that it's enforceable?
Right. So enforcement making powers, fine making powers, also to have monetary consequences in appropriate cases. Again, this is something I don't want to have to use them. I want the possibility of this to encourage organizations to invest in privacy. But other things is the issue of codes and making sure that if an organization is going to spend money to develop a code and to put in place a program, well, that costs them money. And if you're an SME, even if you're a bigger organization, that's an investment. And one of the things that we've heard from industry and from lawyers is that sometimes they have a hard time selling this to management, because what are they getting from that investment? If they're not getting any kind of regulatory protection, it's a harder sell. So what was in the Bill C-27 would say, you develop this code, if it's approved by the Privacy Commissioner, and then you have a complaint against you, then you can point to that code as showing, well, I'm in good faith here. And so it would make it much less likely that you have a fine or that you have even investigation. So to me, that puts the incentive in the right direction, makes it easier for SMEs and other companies.
So thank you.
Way over time. But I did want to give you a chance to respond to it because it was an important question. So, Monsieur Thériault, pour 5 minutes, s'il vous plaît.
Mr. Thériault, you have 5 minutes. Thank you, Mr. Chair. In your opening statement, you talked about an in-depth investigation into X and its chatbot. How's that investigation going? And do you have all the tools to move forward with it quickly? And in your conversation you had with the minister and with its upcoming intentions, will you have even better tools to reach a better conclusion? So start with the second half of the question. In my public and private discussions, I made it very clear that having more powers is necessary. That is very obvious when I made the investigation into 23andMe. Me and my British counterpart made the same investigations. We arrived to the same conclusions, and he was able to impose a fine, and I was only able to put forward a recommendation. So we saw this contrast, and it's very clear because it is a fundamental right, so this power should be necessary, and I'm very optimistic about it, but we shall see. As for the investigation, we will prioritize it. I cannot share a whole lot about current ongoing investigations, but when I initiated it, I expressed my concern related to this phenomenon and the risks related to fundamental privacy rights, especially the rights of young people. So we have the resources, and we will use them to prioritize this investigation. In the process currently, do you think that you have enough means of investigation to arrive at its conclusion? I'm not just talking about concluding the investigation and the penalties, but rather the ability to tackle this issue that's not just present on that platform. Yes, we have our internal resources. Of course, we can always use more, but we understand the current restrictions. We are working with our international partners, so we share our expertise and knowledge, and we use the tools that we have related to the organizations that we're investigating. At the end, if we see that there is a violation and the organization refuses to implement our recommendations, for example, the investigation of ALO and Pornhub, we said that they needed to stop publishing videos without the consent of everyone in those videos. The organizations did not accept our recommendations, and I had to bring them to court. And that takes a lot of time and resources. And in the meantime, our recommendation is not implemented, and Canadians are not protected from these practices. On the spread of deepfakes, currently, do you have recommendations that may allow us to better regulate this phenomenon? In December 2023, I put forward recommendations with my PT counterparts related to AI. And we talked about deepfakes. We talked about that if you use that to manipulate people, if you're using that to create defamatory statements or to spread non-consensual sexual pictures, then that will be a huge issue. Recently, along with the CRTC, the Competition Bureau, and the IP office, we published something related to deepfakes that's related to all of our mandates. In my world, privacy issues are related to manipulating people, as well as the spread of non-consensual sexual content, and use and transparency. We published that in September, and I think that it's a good summary, and it shows that we are collaborating not only with other privacy commissioners in Canada and around the world, but also other digital regulators, such as the CRTC, the Competition Bureau, and others. Thank you, Mr. Thériault. Mr. Hardy, you have 5 minutes. Thank you for being here again. I want to go back on the answer that you provided to Mr. Barrett. You said that you do not have powers to force companies like X to provide information related to their operations. What are the recommendations that you would give the government so that they can act faster to protect people? Well, I have the power during an investigation to ask for information. So when I'm investigating, the act works. What I do not have, it's that if at the end of an investigation I see that the law has been violated, I cannot force someone to stop an illegal practice. For example, you used the example of Pornhub. You said this is what should be done, but it's a recommendation. But you're using a lot of tools. You're doing research, but at your conclusion, they can still do whatever they want. That's what happened. Now, thankfully, a lot of Canadian companies that we deal with accept our recommendations. They talk to us, and then they will move forward with it. But when there is a refusal, that's problematic. And in the case of Pornhub, they turned down 2 recommendations that I think are essential. So first, ensure that there is a clear and direct consent of everybody there. If it's indirect, it can lead to things such as revenge porn. And when information is put there in an inappropriate manner, it needs to be quickly removed, and it needs to be easy for victims to remove that. And the organization still refuses to do so. And that's why I have requested an amendment and to be able to issue orders. People can challenge my decision in front of the courts. That's normal. That's part of the rule of law. However, there needs to be immediate protections for Canadians. So those recommendations were provided to the Canadian government, and you're essentially waiting for them to be enforced. Are there any other recommendations? Because last time you were here, it seems that you said that your office is underfunded, maybe understaffed. Do you feel that there is support? Do you feel that you can reach your objectives? We made very substantial recommendations. For example, a new bill that gives us some powers, and 2, recognizing privacy as a fundamental right, and 3, protecting young people, as well as the protection of the right to remove certain information, as well as the international side. So when data leaves Canada, I think there needs to be more stricter systems. So how many recommendations have been retained? It's been a year since the Carney government. How many recommendations have been retained? I think it will all be in one bill. I'm still waiting. I don't think there will be one bill per recommendation. I think there will be one for the private sector. I think there will be another bill for the public sector. I think that the public sector one will come later. However, I will continue to say that it's necessary to move quickly. So right now, as we speak, the public is no better protected compared to a year ago. Currently, the recommendations have not been implemented yet. I'm using the tools that I have with the best of my capabilities while working with international partners. However, there is an opportunity that needs to be seized by this parliament as quick as possible. Okay, thank you. I now want to talk about AI, identity theft, and the control of information. I know that recently they announced a partnership with the Chinese government that will bring in 50,000 cars. We know that people spend a lot of time in their cars, and in there they will talk about their families. They may even share certain things. And you said that once data leaves the country, we lose control of it. Do you think that there may be a potential danger to Canadians? I think that when it comes to sending data outside of Canada, that's an issue. We cannot completely stop it because international trade is based on that. So we need to find a balance. So protection of privacy, protecting sovereignty, digital sovereignty, national security, while ensuring that free trade can flow. So privacy brings forward things such as consent and transparency. Do we know what's happening? Are we okay with it? Is it easy to say no? Are they used properly? So it's important to look at all that, whether that is in the field of EVs in Canada or around the world, especially when data leaves our borders. Thank you. I think that you will have another opportunity to ask questions. Ms. Lapointe, over to you. You may start. Thank you, Mr. Chair. Welcome to the both of you. Everything is very interesting. When we talk about the government's work related to your recommendations, are you confident that your recommendations will be accepted? The Minister of AI has made public statements saying that there is work underway and that AI needs it. It goes back to what I have said, which is that we need innovation, a strong economy while protecting privacy, and that's possible. Thank you. Earlier, you talked about Great Britain and you compared to the two of our countries. And you talked about 23andMe. You said that you had the same results. Can the British issue penalties? Yes, it's a global genealogy company, and there was a privacy breach. So people were able to steal the data of millions of people, including 300,000 Canadians. So this is genetic data, very sensitive data. So I initiated it with my British counterpart. So we looked at whether the company took proper precautions to protect data. And what we saw is that there weren't sufficient protection systems, bad passwords, and when there were hints that there were bad actors, they did not do enough. We reached the same conclusions. However, my British counterpart had the power to issue orders and to issue fines. I think they issued millions of pounds of fines, and I was only able to make recommendations. It was quite a flagrant situation. We had a press conference, and someone asked me, how is it that I did not impose fines? And I said it was because I did not have the power to do so. So because there were penalties in Great Britain, did that company correct that issue quicker? So what happened is that the company accepted all our recommendations. So when we have the power to issue fines and orders, it pushes the organizations to accept them. If it was just myself, would they have accepted it? Maybe we can be very persuasive. We can publicly criticize these entities and they don't like it. However, when we talk about implementing very expensive measures, if there are no financial consequences, then it's hard to convince management to spend all that money. So, in my view, any manager pays attention to risks, whether that is legal or financial ones. I have another question. Earlier, you talked about the best interests of children and consent. I know that currently there's a trend to not put pictures of your children because usually children who are very young cannot consent to it. So when it comes to all of the pictures published across social media, how do you protect the interest of children? There's also facial recognition. How can we ensure that that does not end badly for children who have not decided to be on social media? That's why protection of the privacy of children has been one of my priorities. They are vulnerable. Often, their data is put online without their consent. So first, we need to interpret the law in a way that takes into account their best interest. It's done in family law and in all other areas of law, but not necessarily in privacy law. For example, saying that the consent of a child needs to be appropriate based on their age and clear. Often, it's their parents who consent, but in other cases, they can do it. Communication needs to be adapted to the age of children. I just created an advisory council in my office for young people. I consult young people and ask them how do they want to see their privacy protected? How do they use social media? We need to take that into account. There's another round if you would like to ask questions. Now we will go back to Mr. Hardy. And I think he wants to share his time with Mr. Cooper. 5 minutes. I have a simple question. It goes back to what I asked earlier related to the Chinese government. Up until now, China has been identified as one of the most dangerous threats to our country. And now we're opening up trade with them. You work with global partners a little bit around the world, in Australia, the UK. Are you comfortable in collaborating with China? Is there open collaboration? Do you have contacts? Do you feel like we can work with them? Do you think that data will be properly handled in the same manner as your counterparts in the UK and Australia and maybe even the USA? Canada is very active on the international scene. There are a lot of networks related to privacy. I talk about the G7. There is also the Asia-Pacific network, so we're working closely with Japan and Korea and Singapore. There are also commissioners in Hong Kong that we work with. we have positive interactions with them. And we like what we see as privacy commissioners. Now, I have not necessarily interacted with the Chinese government when it comes to privacy protections. And what we want to see is a common voice, a strong common voice. And that allows us to issue many statements. Now, when it came to our investigation on TikTok, we had concerns because the Chinese government has strong powers to obtain information from private companies. And we wanted TikTok to say that it is possible that data be sent to China. Was it okay that China accept? TikTok accepted to modify certain things. You have 3 minutes.
Government's cyber security bill, in addition to not requiring judicial authorization before the minister can order a telecommunications service provider to turn over metadata, subscriber account information, website visits, location, financial data, and other personal data. The bill, as you noted, and those powers do not require that it be necessary and proportionate, that the current standard is a relevance one of relevancy, correct?
Correct for one of the powers. There's a number of powers in the bill.
I'm talking about under 15, paragraph 15. Okay. And can you, so that is a pretty permissive standard.
It's much more permissive than necessity and proportionality, which is why I've recommended that it be changed to that.
Yeah, so no judicial authorization and no necessary and proportionate standard. We're talking about some pretty significant information and data concerning the privacy of Canadians. One of the, I would characterize it as excuses that the government has put forward when privacy concerns have been raised with regards to this bill is that they have said, well, there's a lower expectation of privacy with respect to engaging in a regulated activity. And that's true. There is a lesser expectation or reasonable expectation of privacy. But I just want to confirm that when it comes to the Internet, that is not a regulated activity, is it? In fact, it engages significant privacy expectations.
Well, in this case, I have not called for there to be a warrant or a judicial authorization, but I have called, and I am calling for a stronger threshold, which should be, in my view, necessity and proportionality.
Right, but I'm also just saying that this is an activity, the use of the Internet, metadata, all of these things based upon judgments of the Supreme Court engage significant privacy expectations. That's a fair statement, isn't it?
Well, I think it's enough to warrant necessity and proportionality as the standard, so that you assess, do you need it? How much do you need? Don't get more than what you need, but also have you looked for less privacy impacting mechanisms?
Okay, thank you, Mr. Cooper. Madame Lapointe, et je comprends que tu veux.
Ms. Lapointe, and I think you want to share your time. Thank you. Quickly. C-16 was tabled in the House. The law amended certain measures related to gender-based violence, but also covers deepfakes and non-consensual images that are shared. Are you aware of it? Have you taken a look at it? Yes, I'm aware. Now, we are in the world of the criminal code. And for me, the Privacy Act and PIPEDA still play important roles. Not everything falls under the criminal code. But as in the case of ALO, I think that we can also use non-criminal laws to protect Canadians. So I have a quick second question. A lot of witnesses were alarmist and said that superintelligent AI will bring about the end of the world. You met other representatives of the G7 who are commissioners like you. are they just as alarmist across the world? People compare this to climate change or nuclear war. When I attend international events, including the G7, there are all kinds of discussions. When it comes to privacy, my privacy colleagues, we focus on the issue in front of us and the upcoming future, so AI agents. But we hear these concerns at the G7. At the G7, we invited Yoshua Bengio to come talk about his concerns. I believe that these exchanges are very important, but it's not unanimous. Not everybody thinks that's where we're headed. The message that we hear, it's what to do to protect ourselves now. And I think that improving privacy, having elements such as human control and consent are all things that will lead to that evolution be less likely. You have 2 minutes and 45 seconds. Thank you, Mr. Chair. So the right to connectivity is fundamental. I really care about this issue. And I've been lately looking at this. I'm also thinking about the concentration of cognitive power. Unfortunately, that's not just on knowledge itself, but rather also on creation. So, creation of knowledge. What worries me, it's not just this stronger growth of it, of this concentration. It's also that it's concentrated in the hands of a few actors and not equally spread. When people say universal, it's not necessarily across the world and internationally. It's in the hands of a few players. As commissioner, and us as legislators, what is the current framework that we have? And what path should we take so that at the least we understand the problem and understand what do we need to do to ensure that personal data is protected and to ensure that everything else is properly protected. I think we need to use all the tools that we have. In my case, we need to work with other fields, so privacy, but also cognitive psychology. That's very important. Understand how decisions are made. Understand why decisions are not made. Understand how people can be manipulated by algorithms, by messages, and AI. So ensuring that humans have a role in all this. From the legislative perspective, I made recommendations related to more transparency and the protection of private life. So human dignity from day one. As for the small number of players, I believe that requires international collaboration at the government and parliamentary level and at the regulatory level. It will be very hard for one country to regulate it because this is transnational. But having the international community work together is a solution, and that's what we're doing. Thank you, Mr. Sari.
Mr. Dufresne, on behalf of the committee, I want to thank you for being before us, and I am certainly confident in how you handle your file and your staff as well. You bring that confidence to a great degree before this committee, so I want to thank you today for your testimony. Okay.